Good morning, everyone. Thank you for joining us for another great spotlight session. Today we have Maureen Vella, who is a great real estate attorney, and she is very insightful and has a ton of information on all types of different things. I was speaking to her yesterday, where she gave me some insight on this presentation she's doing for us, plus another presentation that she's working on that I think is going to be really, really great once she has it up and running, and I'll invite her back to do that for us. So I'll let Maureen introduce herself and take it away, Maureen. It's all on you.
So good morning, everyone. My name is Maureen Vella. It's spelled V as in Victor, Ella. I am a commercial and residential real estate attorney. I have been practicing law for decades, so I stopped counting after 35 years, so it's been a while. And I began my career as a solo attorney putting out a shingle, which you don't see many young attorneys doing today. So when I did that, what came to me was what friends and family needed, which which I got into the divorce work in the beginning, and of course the residential real estate. So what would happen is I began expanding and expanding to the point where every time you did a divorce, there was a house to be sold or to be purchased, which was really I would say the beginning of why I enjoyed the real estate because it was a little bit different than the divorce work. But what I learned over the years was how to litigate. So what makes me different than the average real estate attorney is that I'm not afraid to take any battle, any fight, and if it's necessary, bring it to court. If it's necessary to fight for my clients. You know that these cases are not easy today, but I am not afraid. I don't say to the client, "Well, I don't do that. I don't go to court. I don't." It's never something that I say, and we make sure to get the job done. Um, I have left my own practice. I've joined a firm. It's called Lyons and Associates, PC. Lyons is um, they have been around for 13 years. We have three offices. The Somerville office, Freehold office, and an office on, well, we're opening a new office in Bergen County, which isn't opened yet, but another one in Morristown. And it's just a very dynamic, growing, expanding firm with a lot of departments. And I am the chair of the real estate and bankruptcy departments. So I've been doing this, like I said, for a long time. I have a full-time paralegal that does nothing but answer the phones, um, send out the emails. We can take most cases out of attorney review the day we receive the files, the day they're opened. Um, and if not that day, definitely by the next day, depending on everyone's availability. But with her name is Jennifer, and Jennifer is amazing to work with, and she knows that that's the priority is to complete attorney review as swiftly as we can, get us into a binding contract, and then schedule all the dates and make sure everything happens. So it's we have it down to a science, I would say. But what I've learned with speaking with agents is that they're always interested in trust and estates because uh, right now they're finding some properties are in trust. Clients would like to put a property into a trust. And I'm sure you all know that your clients just can't put a house into a trust unless their mortgage is also in the trust name, and then we put the deed into the trust. But it's not a difficult process, and it can happen for a lot of people. For some people, the mortgage companies will only do it in their individual names, and the property does not go into a trust. But we do work with them. When you have clients who have senior parents are not yet ready to sell the property, but they want to protect the property. We could put it into we could put any real estate into a Medicaid type of trust, which does not mean that their family is on Medicaid, but it does mean that if we go past the 5-year look back for Medicaid, that the property would be protected from medical bills and from nursing homes and from the end of life expenses that a lot of people end up losing real estate over. So there is some estate planning that's valuable to your clients that we do, and we've done it over the years, and we really will say that we enjoy doing it. So that's where Elise and I, who I work with her, she on she's a great team member. She and I do the estate planning. She and I do she doesn't do the bankruptcy, she doesn't do the real estate with me, but I have other team members. Ashley is another attorney who does the real estate with me. And so just to go over a few things, real estate and estate planning is important because it can save your clients in the future. It can save their homes. Then after you do the purchase, they'll have a home to sell. They will. I would say most people go back to their agent who sold them their home, who they purchased with when it comes time to selling the home. And it's good to help them, and they would never forget if you sent them to someone who could go on to the next step and protect the home. Um, when, what do we do with a trust? When can we look at it? We're going to go over those planning options as well, and talk a little bit about estate planning. Why it applies to everyone. So, whoops, sorry. So all the documents sound nice, but can I afford it? Should I do it? The answer to any of your clients is always yes. You need to do this. It's very important. There's no one out there that shouldn't have a will, a living will, a power of attorney, included in these documents. It's the medical directive and also a funeral representative appointee. But these are important documents to have. Not everyone needs a trust. Just last night, I was meeting with a woman who she doesn't have any children, so she was trying to keep she has a lot of nieces and nephews and is not fond of all of them. She doesn't want there to be any fighting, and she thinks there may be. So she wanted to put the property into a life estate for herself. Now, she just finished doing that in Florida with her condo. And in Florida, you can do a life estate and actually keep ownership of the property, keep control of the property. And in New Jersey, you can't do that. It's something they're looking into, but a life estate means you're actually selling your property. You're giving it to someone, and you're only maintaining a remainderment interest, which means you may live in the property. So it's either you can remain in the property for as long as you live there or for the rest of your life. I mean, the language makes a difference because if someone is still alive, but they go into a senior living, then possibly they don't need the life estate, but it's sometimes difficult to extinguish them. So we really have to look at the circumstances each and every time. So what happens without an estate plan? Someone who passes, dies, intestate. Their estate gets administered just according to New Jersey laws. They have no control, no say. The state may do what they want, but they don't have to. There would be an administrator appointed. The beneficiaries are legal beneficiaries. There is a bond requirement, and it's more difficult. With an estate plan, you can pass property outside of an estate. You can pass it outside of probate, which is most important. You can pass the property to whoever they're really looking to give it to. The transition is much smoother and it's a lot faster. It's easier for an executor to handle an estate when the property is in an estate plan and in a trust. And it's so much easier. You can leave gifts to your loved ones. And it's a discussion that they have beforehand. So it's planned out. It's not just haphazard. Just this week, um, we had a new client that came in and he says, oh, I'm going to help my father. I just helped my father move to Florida. I'm going to sell his home. Well, it turns out that his father wasn't named on the deed. The property was in his mother's name. It was purchased during the marriage. But when the property is purchased during the marriage, and it says married, but it does not have the husband's name, it does not pass by tenancy by the entirety. The property, it remains in mom's estate. Mom passed 6 years ago. So here they've already signed a contract, which they technically couldn't have done. They already put a closing date on it before they brought it to us. And we're pushing the date back because we have to file the estate. All I need is to have the dad appointed as the administrator and get the papers for the administration. Once I do that, then we can very easily still sell the property because now there's an open estate. But it doesn't just pass from husband to wife automatically when husband's name is not on the deed. So there's so many things and discussions that you have ahead of time. Um, of course, the federal state taxes are uh, this number is going up to 15 million now. So the federal state tax is 15 million, so not everyone has to file a federal state tax return, but the inheritance taxes are based on the beneficiary, whether when it's a linear relation and property is passing, it goes from spouse, parent, child. It's tax exempt. There is no inheritance tax. When it's a sibling, son-in-law, daughter-in-law, it's a Class C beneficiary, and the first 25,000 is tax exempt. And then there's a sliding scale to increase the rates. So the taxes have to be paid. There's no way around that. Class D beneficiary is everybody else, and that's at 15% right now for the first 700,000. And there are certain Class C beneficiaries, charities, religious institutions. They're Class D, and it's tax exempt, but it has to go through the Attorney General's office. They review all of those transactions. So that makes it a little bit more complicated when someone dies. So again, I've already talked about the documents. Does anyone have any questions on the documents needed for an estate plan? All right. So again, the last will and testament, the revocable or irrevocable trust, the durable power of attorney, and the advanced healthcare directive and living will. That's one document. And they all have a very specific purpose. With the last will and testament is only a document you need when someone passes. The durable power of attorney is only good when someone is alive. We can do a limited power of attorney if we're selling real estate when someone is not in the state. But ever since COVID, it's so much easier when someone's out of state. We can overnight documents. We can have certain documents, even some that go to the county clerk, can be signed through a DocuSign. There are ways around it. So it's not as important to do limited power of attorneys if we have enough time to plan a sale.
So Maureen, real quick, back on that page. So you're saying so in order to have a full will, you would need all four of these.
Well, no,
Well,
a
not to
will
say
is
a
a
full
separate
will,
document.
but to
A
have every
full
separate
estate
part of,
planning.
yes, okay.
Not everyone has a trust.
Okay.
Everyone should seriously consider a durable power of attorney because when they can't manage their own financial affairs, who's going to do it? Who's going to pay their debts? Who's going to make sure that the lights stay on? Someone needs to be responsible, but you have to be very careful because that document also can give someone the right to sell your home.
Whoa.
Yes. So it's very valuable. We used to always have the power of attorney say it's only effective upon a disability. But
Hmm.
doctors are not wanting to sign off on disability. They don't want to say this person is or isn't disabled under the legal definition. So it's becoming increasingly more difficult to go to a bank and use the durable power of attorney because you need two doctor certifications.
Wow.
So there's a lot that happens with that, and that's why depending on what the purpose is for the power of attorney, if it's a mother trusting her son saying, "I know he'll always do the right thing," great. If it's someone without children and they're concerned, they have to think twice before they give someone a power of attorney over their assets.
Hmm. That makes sense. And
Uh,
then in terms of the revocable or irrevocable trust, what's like the difference between the two?
well, the irrevocable trust is an important document for senior citizens when I'm planning for them.
Hmm.
There's a 5-year look back with Medicaid. So, this whole Medicare, what you have to do with this 5-year look back, if someone's going into assisted living, senior living, long-term care, they if they have property in their name, the nursing homes get the property.
Mm.
So there are things we can do. One of the
Wait,
things,
you said nursing homes get the property?
well,
Yep.
it's not the property is sold and the money is put aside for the person's care.
Ah, I see what you're saying. Okay.
So care today, I'm seeing
Is
care 6,000, 7,000, 8,000 a month.
my grandmother's was 10,000 when she was staying. So
Ah, okay. So
yeah,
so you
it's
understand.
yes, I understand.
So a lot of people lose their homes that way. So
Hmm.
what we could have done for your grandmother is before she was ill, you have to do it
Hmm.
early enough. We take the home. We set up an irrevocable trust. We would name you, let's say, as the trustee. She can't be the
Hmm.
trustee. She can't, but you would make sure she has a home to live in. You're not going to
Hmm.
take the home and sell it. So we set up this trust, and after 5 years, if she goes into a nursing home, they cannot touch the home. So think of the
Ah,
savings.
right.
Um, and that is so important. So you have to trust the people that you're going to name as your trustee on an irrevocable trust. But it's
Hmm.
a very powerful document.
Hmm.
And if it's done early enough, it protects your assets.
Right. Hmm.
Um,
Very
so
interesting.
a revocable trust, well, the lady that came in for the life estate, I did give her the option because she says I won't, she came in for the life estate. She did not want to give the property to her nephew now. I gave her the option. We can do a revocable trust. She can still maintain control over her property. She can revoke that trust. She can sell the property if she wants. She could do whatever she wants with the trust. But
Hmm.
when she dies, it passes directly to who she names in the trust. And it's still outside of probate.
Hmm.
When it's outside of probate, no one's contesting it.
Right. Hmm.
So these are all very powerful documents and important in their own right.
Right. Hmm.
Can I
And
ask a question about the durable power of attorney?
sure.
I just had a closing this week, and the brother of the disabled person who was the owner who was selling the house was the had the power of attorney, and we scrambled around because he didn't have the original document, and the question came up, was it filed, with the secretary with the county clerk? I mean, I think a lot of people don't realize that you need the original document, first of all, because the title company was not going to close this without the original document. And then there was some discussion about whether, it should be filed with the county clerk. What's your thought? What are your thoughts on that?
We don't file them with the county clerk. Doesn't mean we shouldn't or couldn't. You could file a will as well, but then it's on record for everyone to see. I don't know.
Hmm.
With fraud today, I don't like a lot of things filed that don't need to be.
Hmm.
So it's not something we do. Um, and I would say 90%, 99% of the attorneys don't file them.
Right. So make sure you know where the original is, basically.
Well, what we do with our clients for all of these documents, we put in writing when we do them. The originals are going home with you, or the originals are in our office. So first, so we have that list on our computer.
Okay.
We also, so any relatives that call up and say, you have my mom's, you have my mom's will, she passed, and I look it up and I say, well, the original went home with your mom. And I could tell them that. So it's, valuable information. But I always tell my clients, you have to put this in a fireproof box. Long time ago, everyone used to put them in their safety book deposit boxes, and then then came a time where all of the safety deposit boxes were sealed when someone passed, and they couldn't get to the will fast enough.
Mm.
So I mean, so we always
Yeah.
back in the day, I still hold on to some wills only for
Yeah.
seniors, when they
We,
don't
we
have
we
them.
ended up we were at the law firm where the brother had done the work, and we ended up actually going into the basement and digging through boxes to find the original.
That's not where it belongs.
It was like 2 or 3 hours of just red tape, just trying to close this before we went to the closing, and it was complicated, and I think none of us really were aware of the fact that it had to be original, and that we had to find the original, and that was the linchpin to getting the thing closed.
I
Right.
have done this a couple of times. We have made multiple copies of the power of attorney and have signed them all.
Yeah,
Hmm.
So I've done that. I don't do that often because people change their minds and they think, oh, I just tear up one document, I'm done. But that
right,
doesn't really take care of it.
right.
Yeah.
Multiple originals.
Right. We have
Right.
one question in the chat. Says if all the documents you mentioned just now, if we have that since 23 years, can we update it, or we have to create it all new, or can it be updated?
All right. So let's talk about the different documents. The powers of attorney that were created 23 years ago do not have the new statutory language in them.
Hmm.
Banks will tell you we cannot use this. So a power of attorney should be updated. It's the very specific language. It's in the statute. It has to be in the document. And so most of my clients, we've updated their power of attorneys. Last wills and testaments don't have to be updated. Now it depends. If someone's passed away who was receiving, their gift would lapse. Or
Hmm.
if they have children, and depending on what the will says, it could go to their children. So it depends on the document. The way I draft the wills is in the event so and so, one of the beneficiaries passes away. Even if they don't have children on the day I draft the will, in the event they have heirs at the time, their share would pass to their heirs. So we cover that. We also cover what happens if there's no heirs. So there are ways to do this and get around it. So it depends on the will. If it's to take someone out of the will, I wouldn't. So to update a will, you could do a codicil. It almost costs as much money to do a codicil as it does to update a will. Um, and yes, it's almost easier to do a new will because the people who are removed don't get to see the old will then. It depends on the circumstance. So you can do a codicil. It just, would update whatever needs to be updated, or you can do a new will depending. Power of attorney, I would say absolutely. A trust should not need any updating unless you want to change the terms. And the advanced healthcare directive and living will, I would ask them if they've changed their mind on what they want to do and discuss with them what it means to be left on life support, for how long, make sure it's specific. Whether or not they're leaving their organs to science, and whatever else they need to, who they need to appoint, who they want to be in a hospital room with them. So all of this is done with that in mind. So the answer is it depends.
Thank you.
You're welcome. Um, Again, all adults should have the documents: last will and testament, durable power of attorney, advanced healthcare directive. The trusts, business agreements, and professional wills. Professional wills are a way you can take your practice and say, I'm giving my practice to so and so when I pass. If you have a family member you want to do that with, it's a way to pass down your business. but a lot of people don't do that today. But if it was, a law practice, then I would say you need to have that. But well, the other documents I think we've covered, which are, I would say, necessary for an estate plan.
Hi, Maureen. I have one question.
Sure.
Does the trust need to be filed?
The good thing about a trust is that they are not filed,
Okay.
and so no one knows your property, who it's going to, what's happening to it.
Uh-huh.
Depending on what's in the trust, we've already changed the deed to the property to state that it's in the trust, and if the trust is going to continue beyond your life, then the deed doesn't have to be changed. If it's not going to be changed, if the trust is going to, if the property is going to beneficiaries, then the deed is going to be changed, but they're not filed. They are the way. Now, this is getting into more of a specific question regarding taxes. Some trusts you can do and use your social security number for.
Okay.
Some other trusts, like an irrevocable trust, for example, you have to have a tax ID. And some trusts require, because the income they're making interest income, depending on how they're set up, they actually require a tax return filed. So the trust itself might not be recorded or filed, but some of them need tax returns.
Okay. Thank you.
You're welcome. This is, I know I went over this, but I'll just, do it again, because this is a question that a lot of agents have had when I start talking about this. When a revocable, when an irrevocable, what do we need for ourselves? What do our clients need? Are you trying to avoid probate? That's the question. Can you put all your assets into one place? Can they just pass then without probate? That's a revocable trust. You can change it at any time. You maintain control over your assets. But just because you have the trust document, I've seen many people make this mistake. They don't take the next step and actually have the deed changed. And if the deed is not changed and put into the trust, it's not part of the trust. The actual title on the deed has to be in the trust of. It's from the individual, and it's put into whatever their family trust name is. So that's important as well.
Maureen, the deeds of, let's say, a couple has two properties, one the primary, one the investment. Then we make a trust. We have to change that deed into the trust name, both the properties.
If you want those documents to be in the trust, yes, the deed name must change. Now, you can't do this if there's a mortgage on the property, because I know I've seen it done many times, and I'm sure you have too as agents, where your clients have actually taken the property and changed it into the trust name, and there's a mortgage on it. The mortgage company, if they get a hold of that, they can call in the entire mortgage and say, you've transferred the property out of your own name to keep yourself not liable to creditors, and now we don't feel protected as the mortgage company, and you, according to the mortgage, and every mortgage has the clause, then you cannot change the name. So it's dangerous. I would not recommend it. I know clients who have done it. I know people who have done it. And I think it's not advisable, and it's not something I would ever do.
So what is the ways to protect it against the medical or other liens apart from mortgage to protect these properties?
Well, from the medical that I told you about, for the Medicare, for the nursing home, the big bills, that you need the irrevocable trust. That's how to protect it. Assets in the trust are generally so I guess well, let's talk about the irrevocable trust, because again, still avoids probate. That's a good thing. It is a tax shelter, avoid certain tax penalties. If someone's going to receive government benefits, then you want to make sure that property is not in their name at all, and it's in the irrevocable trust. So those are the specific type of trusts. They're more expensive to do. They're the ones that require the separate tax return. They have to be filed annually. People don't always do that too. They must be filed annually. And the grantor cannot be a trustee. The grantor of the trust cannot have any power over the property. And they can't get the property back into their name. The trust can be terminated, but they can't get it back into their name. So both trusts are good. If you want to protect from creditors, though, a better way to do it is to put the property into an LLC. Putting property into an LLC, if they don't have a judgment against the LLC, they're not going to be able to pierce the veil unless they can prove that you are just hiding your assets and put it in there when you knew you had a debt that was owed. So,
Oh,
and we didn't
thank
really,
you.
you're welcome. I won't talk too much about this because I've already taken a lot of your time, but the estate planning documents for the business edition, there are professional wills. I did mention that. It's really good to do this if you want to make sure there's some continuity to your business. If you're set up as an LLC and you want to make sure that it passes to someone else, a professional will is the way to do it. You should have operating agreements as part of the LLC, and you should have a shareholder agreement if it's a corporation. These are important documents if you're setting property up and you're putting it into an LLC. You don't need the operating agreement if it's a single member LLC, if it's just yours, just one name. But if you're going to be sharing real estate with multiple parties and you're putting it into an LLC, you must have an operating agreement. And that's just important planning as well.
And you also draft that, or somebody else.
I'm sorry?
Do you draft that as well?
Oh yeah, all of these
Okay.
documents.
Okay, great. Thanks.
Okay, let's talk about estate planning. What's important for real estate? I think that's really what we want to talk about. The wills, say who's getting your property, to what degree, to what percentage. Estates often contemplate real estate sales, transfers. All of that can be put in to the estate planning. We talk about your finances, who your beneficiaries are, what is your plan? And the UTMA and UGMA accounts are financial accounts for children. All of that, what you have, what's set up. We are not financial planners, but we talk about what you have, what your picture is, and what you want it to look like down the road when the children are grown, when the children are out of the house. What are your needs? And that's part of the estate planning. Most estate planning has some kind of tax consequence, estate tax. We all wish that we could be subject to estate tax because that means our estates are very large. But the inheritance tax, we try to avoid that whenever possible. You have limits on the gift exclusion. And we make sure that you have the right people are designated as the administrator or the executor of your documents. And we talk about that. We make sure you have enough alternates. I like on my wills to have 2 alternates for everything. So basically, if you're alive, you need an estate plan. So I'm sorry that I have Elisa's name on here, but like I said, we were doing this together last time, and I didn't get to pull the right one up, but my name is Maureen Vella. How do I stop sharing? Can someone help me with that? Here we go.
There you go.
So my name is Maureen Vella. I've been doing this, like I said, for decades. it's second nature. I am first and foremost a real estate attorney. So if you'd like to give us a shot, give me a try. I think you'll be very, very satisfied. Your clients will be very satisfied, and they would thank you. They would say that that things went smoothly and quickly, because like I kept saying, I can't share a paralegal with real estate who does other things, because with real estate, it is so time driven to when the contract's signed. And when when I was sharing a litigation paralegal, it wasn't working for me because they had to work on their timeline for their litigation documents, and I needed documents that day. So I have a dedicated real estate paralegal who 24 well, for 24/7 she'll answer my calls, but from 9 to 5, and even longer, she works till 6 or 7. She's available to the clients, and she just gets things done. So I'd like an opportunity to try working for one of your clients and see if I can make you satisfied that it's going to be handled quickly, efficiently, and that if there's any problems, I don't hesitate to make the necessary. I don't want to say that I'm aggressive, but if someone is doing the wrong thing on the other side and they're not closing, I wouldn't hesitate to take it to court. So, which is good to know. So, again, Maureen, Vella, I've been doing this for a long time, and if you have any questions, I'd love to answer them. But it was wonderful meeting you all.
Awesome. Thank you so much, Maureen. I learned a lot today, definitely about, all this stuff, and I'm about to get it all together. I'm probably going to call you for it.
Wonderful. Well,
Awesome.
here's what I can do, Lawrence. Lawrence, I talked to you a little bit about it. Was that one of the other agents? The agents were very thrilled with the information, the level of degree of knowledge. They wanted to get more people into their office, so they wanted to do the in-person seminar. Which I'd be happy to come and do if you wanted to open something to the public and have all your
Yeah,
agents bring in
absolutely.
people, just to say we're the office to help you with your real estate needs. And I think this type of information on the estates is what brings people in the door.
Yeah, absolutely. I agree, because it's one of those things that people don't really think about until it's, way down the line. But it's definitely something good to think about, when you're, a little bit younger and a little earlier in life, things like that, to kind of have those things set up, because you never know. Yeah. So, but thank you so much, Maureen. I really appreciate it. Guys, I put Maureen's information in the chat. Feel free to give her a call or shoot her an email if you have questions, comments, concerns. And again, thank you, Maureen. I thank you for coming here today and taking your time out of your busy schedule to educate us on this.
Thank
You
you
guys
so much.
all have a great weekend. Maureen, I
Thank
will definitely
you.
be in touch about, your next course, so we can talk about that.
That
And
one's going to be very interesting.
yes,
Should I give a
that's a
little
very interesting one.
sneak preview to everyone?
Yeah.
Yeah.
All right. So, I know a lot of agents want to learn, what are the pitfalls when you're representing a party in a divorce. So how to be a real estate divorce agent. I mean,
Mm-hmm. That
just
is,
what's going on, what it means,
mm-hmm.
like where your hands can get tied, what pitfalls to avoid. So I'm putting that together. It's not finalized yet, but that's going to be an interesting one as well.
Yeah, I'm very interested in that one. I've dealt with a listing with a divorce, and it was one of those ones. So
Sometimes they are. Someone's not cleaning up the property. Someone's not getting out of the
it
property.
was it was
What
it,
could go
it
wrong
was
will.
yeah, it wasn't, yeah, it wasn't great. So but thank you so much, Maureen. I really appreciate it, and I look forward to having that presentation here as well. You guys all have a great weekend. Thanks a lot for coming.
Thank you
Thank
for
you
having
all.
me.
Thank you,
Absolutely.
Appreciate
Maureen.
it.
Thank you,
Bye.
Lawrence.
Thank
Have a
You're
you.
nice
welcome.
day.
Bye.
Bye, everyone.
Thanks. Bye.
Bye.